Hello, and welcome to the Global Summit on Economic Abuse. Before we begin, I'd like to go over some general housekeeping. You are signed in as a participant and your camera and microphone are disabled. Today's session will be recorded for future viewing. If the contents of this session raise any issues for you, we encourage you to take whatever steps you need to prioritise your own well-being. If you'd like to reach out for support, you'll find a link in the chat to the No More Global Directory of Specialist Domestic Abuse and Sexual Violence Services. Finally, if you have any questions for our guest speakers today, please type them into the Q&A box. We will address as many questions as possible toward the end of the session. Thank you for your cooperation, and we hope you enjoy today's session. I'm Nicola Sharp-Jeffs, and I'm a co-founder of the International Coalition Against Economic Abuse, and I'm going to be moderating today's session, Justice for All. As our understanding of domestic abuse deepens, there's growing recognition that domestic abuse isn't always physical. It can take many forms, including economic. Laws are increasingly acknowledging economic abuse as a form of coercive control that has serious and damaging harm, and in response, the justice system is undergoing significant scrutiny and change. Today's session focuses on how both the criminal and family justice systems can better identify, investigate, and respond to economic abuse as part of a more comprehensive justice response. We've brought together a powerful mix of voices, frontline justice professionals, legal reform advocates, and researchers to examine the real challenges that we're facing. So let's meet them. Dr. Marsha Scott is the Chief Executive of Scottish Women's Aid. Angela Lynch is a lawyer and a sexual, domestic and family violence prevention advocate. Jenny Beck Casey is an award-winning family lawyer and the founding director of Beck Fitzgerald. And Dr. Cassandra Vina is an associate professor in law at City St George's University of London. Thank you everyone for joining me today. So let me start by asking you, Cass, as an expert in coercive control and the criminal law, what coercive control is, what criminal provisions exist in England and Wales to address economic abuse within this context, and how well do they achieve this?
Hi, thanks, Nicola, and thank you very much for inviting me to be here today. So coercive control, when people ask me what coercive control is, I often give a very, very short vignette because I think the best way to explain what it is to show rather than tell, if that makes sense. And one of the first stories that I came across in my research was a young woman who told me that she had fallen in love, gone on her honeymoon, was having an incredible time, and then on the 5th day of her honeymoon, her new husband lost his temper, asked her to do something she didn't want to do, and when she said no, went to the bathroom, got a towel, and nearly strangled her to death with the towel. Horrific, horrible incident with the towel. And from that moment on, for 6 years of their marriage together, because it took her 6 years to escape, he would tell her to do things, and if she hesitated, he would go to the bathroom, get the towel, and he would put it on the kitchen table. And then she would do whatever it was he asked him to do. Now, that is, for me, sums up the relationship between the threats, the intimidation, and the control. It's a compliance demand situation backed up with threats that the victim knows could be carried out at any time. So that's control. And then as for in this country, England and Wales, what we, the legislative infrastructure, as you know, and everyone here will know, in December 2015, we took the really progressive step of becoming the first nation state in the world, actually, to make coercive control a criminal offence. Section 76 of the Serious Crime Act makes what it frames as coercive or controlling behaviour, which is now often referred to as CCB in this country, a criminal offence. And as is often the case with a country that goes first, there are things that work about it, and there are things that really we could have done better, unfortunately. How much time are we quite short of time? How much more detail do you want me to go into, Nicola? Have I got time to say a bit more?
Yeah, I think you've got another couple of minutes if you want to say a bit more, expand on that.
Okay, so I think if I was going to pick out the most important things that I think are working really well, about Section 76. It would be the way that it frames the crime of coercive control as repeated or continuous. And although that sounds like a small thing, it's actually a massive shift for the criminal law, which historically and traditionally frames crime as an incident. So imagine a crime thriller series you're watching on TV. Where were you when it happened? Is the kind of the way that we try to pin a criminal event to a time and place. And what is so fantastic about that paradigm shift is it matches with what victims tell us about how they experience abuse. And it means their experience of giving evidence in court is a lot smoother because instead of desperately trying to remember where they were at a particular moment, which feels irrelevant in the context of 5 years of abuse, they can actually tell it like it is. So I think that has, much to the sort of doubters' surprise, worked really well. Judges like it, lawyers can handle it, it turns out, who knew? And actually, that's been much smoother than people thought. Now, in terms of what isn't working, there are probably two really critical things that I want to highlight that I think have been a really big mistake. The first one is that we didn't define coercive control in law when we drafted our somewhat shoddy Section 76. That was largely because the people who were drafting didn't really understand the behaviour they were criminalising. And as a result, it means there's a real degree of uncertainty in policing, CPS, judicial circles about which bits of the behaviour are control and which bits aren't, and how do we charge that and how do we prosecute that? So that's the first mistake. And the second mistake, I think, is that we've given control a very low sentencing cap, 5 years in this country, which means that for police and prosecutors, it's sort of positioned as a low-level offence, somewhat akin to, let's say, actual bodily harm, which is bruising on the skin, for example. And as a result, it means that we're not really getting it right, literally from the first moment a woman reports right the way through to trial, in terms of how we are framing, navigating, and dealing with the behaviour. Now, Scotland came along about, I think, 3 years later, Marsha can confirm, and surprise, surprise, did the whole thing a lot better. But I will let Marsha tell us more about that.
Absolutely. And I think that piece around the 5 years maximum sentence is so important because we do
Mm.
know that perpetrators often go on and abuse other intimate partners and or family members. So do remain, a real risk in terms of public protection. So definitely something that needs looking at. Before we move across to Marsha, can I just quickly ask you perhaps just to make reference specifically to economic abuse within the CCB offence and how well you think that it manages that? As you know,
Yes,
I've been
of course.
monitoring the successful prosecutions, and we do see around 60% of those having some form of economic control within them.
I would say it's probably more than 60%. What you're seeing with the prosecutions is just the bit that gets talked about in court. And actually, part of my work is, studying the judgments and observing trials and stuff. And what I would say is it sometimes can feel a bit random, the bits that get reported and the bits that don't. In my experience, economic abuse is the underpinner. It is absolutely structural for coercive control. It's the bit, in some ways, it's almost the most important piece. And, I know the story I told about the bathroom towel. I'm not trying to take away from the very real reality of the horrific eggshells and fear that a survivor lives with. But the reason that woman in that story took 6 years to leave was because she had no money. So he controlled the money. She had no access to funds. She didn't have her own bank account. Her money got paid into his account. All the bills were in her name. All the assets were in him. And that I like to call it the underpinner because for me, it is the structural constraint. And it also ties into all those things we know about gender inequality and the wider kind of feminism agenda, because actually, unfortunately, our structures still in 2025 are set out in a way that makes it really much easier, I think, for a man to position a woman, a female partner, in that way when it comes to the economic abuse straitjacket than it is the other way around.
Absolutely. Lovely. Thanks, Cass. So we're going to move across to Marsha now. Cass has already made reference to the law in Scotland, and I know you were involved in the development of the Domestic Abuse Scotland Act in 2018, Marsha. You also work as an international consultant for the Council of Europe, looking at criminal and civil justice responses to domestic, including economic abuse. So in your view, and in Cass's view, what's better about the Domestic Abuse Act in Scotland, and how does that address economic abuse?
First of all, a big hello to the sisters in Australia who I get to spend time with occasionally. Spent some time with somebody from Canterbury yesterday. Um, uh, Secondly, well, we don't have enough time for me to tell you all the things that I think are a little bit better about our bill. But at the end of the day, it only matters if it matters for women and children. So um, I think for me, the top headlines about why Evan Starr called the bill the gold standard for legislation in the world is that it moved away from focusing on the behaviors of the victim. Was the victim harmed? Was the victim distressed? And focused all of the measures for criminality on the behaviors of the perpetrator, which I'll get back to when we're talking about economic abuse. Um, uh, so it's not a victimless, it doesn't enable a victimless prosecution, but it comes very close. And it doesn't mean that the prosecution can't lead evidence of harm to the victim and the children. Unfortunately, they were not co-victims, which we wanted. But they don't have to in order to prove criminality. Another really strong part of it, and as Cassandra mentioned, is that it's now a course of conduct crime rather than incidents. And there's been a recent appeal which has strengthened that mechanism of it, which says that the course of conduct is the criminal behavior rather than the incidents in them. So, but it's still, I think, a little flawed, and I agree with Cassandra around that. And the other, I think, the other test that's really important is that you don't have to prove intent. So there's two grounds on which you can, you need to prove one or the other. One is, did the accused intend to cause harm? And that's very difficult to prove. But the second one is the innovative one, which is, or would a reasonable person, when hearing the facts of the case, assume that the perpetrator, the accused, excuse me, was reckless in the face of harming the child or the woman, which allows a whole lot more to be led in the court. So those are, I think, the two things that really distinguish our legislation from previous, and also from a lot of the existing legislation that's come since then, which is really moving the focus from is the victim harmed, which requires that she come into court or the police station and share a litany of her own trauma. And then often it was a lose-lose in courts, still is, unfortunately, which is if she was distressed, she was hysterical and not reliable. And if she was flat and calm, then she was lying. So it's moved the whole process of court away from that. So I would say those are the probably highlights of it.
And in relation to economic abuse specifically, you said you were going to circle back to that.
I think there's I think the story will become more and more alike as we all talk about implementation. The biggest challenge, and we've had some successes with working with colleagues in the Crown Office here and the police about pointing out how few prosecutions look at economic abuse. And we're doing a whole big piece of work on public debt as a form of economic abuse. And one of the difficulties has been that if you don't understand coercive control, you don't understand you don't look appropriately for economic abuse, and you don't identify it. And the core problem is that we have people using a law that they basically don't understand the dynamics of, and which is why it's taking, and it was always going to be a transition, but it's taking a long time for police to get skilled up to be able to identify. And what prosecutors tell me is when you get good evidence collected by police who actually understand coercive control and know what to look for, then you're drowning in evidence. And economic abuse is one of the areas you will have, an enormous amount of evidence in terms of financial records, in terms of, telephone records, yada, yada. But they have to look for it, and they have to provide that to the Crown, and the Crown has to send them back if they don't provide that. And I'll just finish this bit. So they're working on how to improve their training to identify the two big areas are economic abuse and impact on children from our perspective, or behaviors with children. And then how to include that in the protocol that they're rewriting right now between the Crown and the police. But I also think that it's very important to understand that the gift that coercive control gives us, and that Evan gave us, is that it's an incredibly good tool for revealing the things that constrain women's choices and options in the face of abuse that are structural in nature. So a woman's poverty is probably the biggest driver, poverty of power, poverty of income. And even when she's relatively high income, her access to those assets is obviously greatly reduced in the context of economic abuse. We recently did some research. 90+% of the survivors that our staff were working with, when you talk to them, were evidencing economic abuse. So the figures are, I would say it'd be really difficult to find one, very many cases where economic abuse isn't happening, because it's such a nice tool that the system hands to perpetrators. Okay,
yes. And as you said, Marsha, and Cass referred to, that deep inequality, makes it easy for perpetrators to take advantage of that inequality, certainly. So just for anyone who's not aware of Professor Evan Stark, an amazing academic who sadly has left us, but has left an amazing legacy and has done a lot of writing around this issue. So thanks, Marsha. Before we move across to Angela, just very quickly, what have you learned from other jurisdictions in this space? Because I know that you often get involved in the development of criminal and family justice in other countries. Is there anything that you've taken away that you would love to see in Scotland or the United Kingdom more broadly?
I think that I wish I had a better answer on that one. I mean, I have to say, the work that I do for the Council of Europe, there's some amazing people out there who understand domestic abuse in really different judicial and legal systems, and try and make that so in their courtrooms, for instance. But the real lack of understanding of the mechanisms of coercive control really have hampered people's understanding of this, of how you manage, how you reflect economic abuse in the trauma and harm that perpetrators visit on their families, and the impact that it has on women's ability to report, on their desire to report, on their ability to get themselves and their children safe. So I wish I had a good news story. And, God knows I've missed a lot. I'm, not aware. Oh, there goes my scarf. Too many, a lot of places. And it may well be that the other panelists have better examples. But I do think that one of the things that our law offers that a lot of them don't is we have really extensive guidance notes, happy to share with anybody, that give examples of, that are not restricted. It's not an exclusive list, but they just say things like restricting someone's money and food, restricting someone's access to their money, restricting someone's ability to work, do paid labor, those kinds of things. So it's quite specific about what it might look like. And I think and the outcome that it has about restricting women's freedom and autonomy. And I think those are tools that we will be glad we have in the future, and that I would recommend to people now to be thinking about really creating very specific examples, like Cassandra was saying.
Yeah, that's really helpful. Thanks, Marsha. And you made reference to people from other countries on the panel. I'd love to welcome Angela into the discussion now. Angela is based in Queensland in Australia. Angela, I'm aware that you've delved into the impact of criminalising into the impact of criminalising coercive control on family law. So could you tell us a little bit about that? What impact has an improved understanding of coercive and controlling behaviour, and in particular economic abuse, had in this space? And again, what do you think needs to change?
Yeah, so in Australia, we're in relation to the criminalisation, we're a little bit behind the UK and Scotland. New South Wales was the first jurisdiction to criminalise just over a year ago. Queensland criminalised, and it's been operational since about May, but it's only a few months. And a couple of other states have come on board now with intentions to criminalise, but they haven't. That hasn't been put into legislation as yet. So I worked with actually the Women's Legal Service New South Wales, which is a feminist organisation in New South Wales, where where it had been criminalised, and we looked at some case law, family law case law, and said, has the criminalisation had any impact? Because we're actually interested to know if there was an impact. We hadn't. And the reality is, it's still too early to know. The cases are, no case in either Queensland or New South Wales has gone to court yet, so there's no sort of trial decisions. Oh, sorry. Also, all of the definitions cover off on economic abuse as well, in relation to criminalisation. Yeah, so it's probably too early to tell, but there have been major changes in Australia in relation to family law, economic abuse and financial abuse. So, yeah, landmark legislation was passed last year. It came into operation on the 10th of June this year, recognising in the family law property settlements domestic and family violence in the legislation. So there is a requirement now to take into account the impacts of domestic and family violence in relation to property settlements, both in relation to contributions that are made and if they've been made more difficult, but also into the future as well. So they look at the future impact. So family violence is a necessary requirement to consider in relation to future circumstances. They also legislatively need to take into account appropriate housing for children. There's also issues around specifically around reckless wastage and wastage of assets. And also something also in there for consideration around liabilities incurred by one party, obviously, you know, in a financial abuse situation. They also really, I mean, financial abuse was always able to be taken into account. It was part of the definition of the Family Law Act, but they've really expanded the definition of financial abuse in the Family Law Act and really extrapolated a whole lot of different examples. So this we know already is having an impact in family law practice. It's really probably taken that clear legislative guidance rather, because you could always take it into account, you could always take wastage into account, but it was locked away in probably case law, whilst putting this into legislation puts it front and centre in relation to how people, obviously in court, obviously in how mediation and also negotiations between themselves, across the kitchen table, and or you know, through mediation centres and things like that. So we don't know at this stage. Again, it's only been in since the 10th of June. We do think it is having an impact. We can't say what it is as yet, but it is actually quite positive. It is you know, a monumental shift. And I think that it is having an impact, but we just don't know as yet. So at this stage, the criminalisation it's a bit of a very slow uptake of that. So we haven't then been able to assess that, the criminalisation aspect, into family law. But also, like, I suppose parallel, there's been there was a change in leadership in the family law, the family courts here in Australia, and we had a new Chief Justice. He's been in place a number of years now, but quite very motivated in relation to the space of family violence, and got all the judges, all of the judges have been trained with David Mandel's Safe and Together, brought David Mandel over at great expense. All the judges went through this training. I think they still go through the training, or the family report writers go through the training. So just in relation to generally, there is an uplift around knowledge, case law. There's lots of case law in family law around coercive control, mainly relating to children, but it will come through in relation to property as well. And you can see from that case law, the knowledge of judges has remarkably increased, and obviously the lawyers as well. But again, we don't know. Australia is a big country. And the further you get away from the metropolitan areas, and perhaps the seat of power, that you know, like Sydney and Melbourne, there could be differences in how coercive control, economic abuse, and things of that nature are kind of translated into practice. But again, it's a bit of a wait and see. It's quite exciting, but it is a bit of a wait and see at this stage, because the laws are quite early, and we'll have to wait for them to be settled, and obviously go through some court cases and some litigation, and we can see in relation to specifically those property settlements, we'll see if there's, you know, some real change. Yeah.
Yeah, it is exciting. Thanks for sharing that, Angela. I know it's really early days. At the moment, is there any kind of glaring, obvious gaps or omissions, or again, is it too early to say, would you say?
Well, I mean, these changes have been brought in from women's services advocacy over decades. I don't think at this stage that we would say that there are any obvious gaps. It probably is it's about waiting and seeing. There would be always gaps in relation to practice, ability to get legal aid, ability to get in to see a lawyer, a lawyer's ability to translate these arguments effectively into, you know, their arguments in court. So those are the things that the laws are there, but it's around those other issues as well. But I do think it really will have an impact, because it's in the legislation very clearly. There's been a big emphasis on it. It's something that can't be ignored. And we also know, like the big change over here as well is they did the statistics on how much domestic violence was going through the court, and the statistics were 85% of the family court, there is allegations of domestic violence. So when you're talking about a court, you're not talking about a family court, you're talking about a domestic violence court. That's a domestic. If you've got 85%, and we know that, you know, that there's an underreport around domestic violence case matters, then you are talking about a family violence court. So there is, I suppose, still advocacy around the shifts in relation to what that means, probably around safety and things of that nature. But there's certainly real potential. But it's probably, we also probably have to see, is there going to be adverse impacts? You know, are perpetrators going to fight more? Are they going to raise issues that they're victims? I mean, they do that already, but is that going to happen more? So are there sort of some perverse outcomes from doing this? And we don't know that yet either. There's usually some sort of outcome that you kind of haven't, you know, like you haven't expected.
Yeah.
So we will just have to wait, but at this stage it's positive, but we just have to wait for things to settle. I wouldn't be able to say there's something else that needs to be done. I think there's been major changes. There are positive, they are quite positive. Let's now see what happens in practice. Yeah.
Thanks, Angela. Such food for thought there, and really powerful, that piece around 85% of the business being related to family or domestic abuse, as we might say, certainly in the UK. which is kind of the perfect link across to our final panelist, Jenny, who is a family lawyer here in England and Wales and specialises in complex disputes relating to finance and children. So Jenny, welcome. Having listened to Angela just now, to what extent do you see those issues raised by Angela in the UK system, and all other different challenges that we are responding to?
So yes, thanks very much for having me, Nick. Yes, very similar issues in the sense that we have probably an underrepresentation as well, but a significant proportion, in excess of 80%, I would imagine, of cases going through the courts which are concerned with domestic abuse. I operate in the family courts, and one of the major problems we have is the disconnect between the family and the criminal courts. So we'll have, obviously, for the victim survivor, an identical set of circumstances, and they will be required to operate under two entirely different and disconnected processes in order to seek safety for themselves and their family, but also to seek justice. A criminal process, which is unlikely in many circumstances to actually result in a prosecution, because it's in spite of the act that Cassandra's referred to and the fact that we were the first to the table with that act, it's under prosecuted, and the standard of proof is the criminal burden, and it's more difficult to secure a prosecution for a number of different reasons, to do with evidence and to do with the process of the way it works. Now, we've got, of course, our Family Law Act, which came in 2021 and is a progressive piece of legislation, albeit that it's a bit gender blind. It recognises coercive and controlling behaviour and economic abuse in the definition of abuse itself. And as a result, it's extremely helpful for us in terms of pushing that particular agenda. The difficulty, of course, is that you can have an entirely different process in the civil court and in the criminal court, an entirely different outcome. I had a case literally just a couple of months ago where we had 19 findings of really serious coercive and controlling behaviour, including economic abuse, in the civil courts following a 5-day fact-finding hearing. The same case was in fact prosecuted and went to a 12-day criminal trial, after which the perpetrator was acquitted. So identical facts, entirely different result. And for the victim herself, the perpetrator then took her back to the family court to say, well, look, I've now been acquitted in the criminal court. I want to, the issue was all about contact to the child and the danger that he posed as exposed by his abusive behaviour. And of course, he's now coming back to the family courts to say, well, look, here I am, completely exonerated by the courts, and so I want to reopen the family case. So the lack of connection between the civil and the criminal is a real issue for us. I also feel I'm really interested actually in what you've been talking about, Angela, and about the focus on domestic abuse being taken into account more in property settlements, which is something we're lagging behind in. It's very hard to get conduct and domestic abuse and economic abuse taken into account, and yet we know it's one of the reasons why, you know, the cases that don't come to court don't even get to court, because people are settling way beyond the idea of ever going to court, because number one, many women can't, because they don't have the economic wherewithal, and our legal aid system doesn't provide them with the ability to get to court in the first place. But also those that do, even when they're capable of proving they've been victim survivors of economic abuse, that isn't being taken into account in the settlement that they receive in the way that it should. So it's really interesting to hear that progressive step being taken in Australia. I'll be interested to hear more about that. So yes, I'd say that the disconnect is a real issue for us. I'd say the failure to recognise the far-reaching impact of economic abuse, and of course I completely agree, it's in every case, and it is the actual mechanism by which that abuse can continue. And I think the problem, of course, for all of us is the sort of cultural marginalisation of abuse and particularly private abuse. You know, we talk a lot about, certainly in Britain, we have a commitment from the government to halve VOG, but it's very difficult to get domestic abuse and within that economic abuse to really be understood properly. And I fear that we're also lagging behind in the training program that Angela's talked about. I recognise that we do have a training program, and I would imagine our judiciary would feel well trained, but it's quite difficult to really train in a proper understanding of economic abuse because our adversarial system is actually entirely designed around finding evidence for specifics and not for patterns. And that's why we've got a real job of work to do. We have actually had some very good cases which have said, no, you need to look at the entire context. Coercive control is a process. There will be a series of incidents, but still, when we train our lawyers, when we plead our cases, we allow the evidential tail to wag the dog, and we basically say, well, we need to be really quick because we haven't got much funding. So tell me the worst thing that's happened. And people go, oh, well, I had a towel wrapped around my throat. They don't say, and now, ever since then, I have to do every single thing I'm told. And that is actually the more dangerous abuse. I'm not belittling the towel abuse. I'm just saying that is more likely to lead to a homicide. So, yes, I think we're not training as well as we might. I think we're failing to recognise the impact within the wider family context of financial settlement. And I think we have a disconnect between the criminal and the civil system, which is bemusing, and it really hobbles people's attempts to actually seek help in the first place because it's an impenetrably complex system, and people see people getting off and not being prosecuted, and they think then nobody's going to believe me.
Thanks, Jenny. That's an amazing summary in that, story you tell about the finding of fact in the family court, but no prosecution happening in the criminal. I think really illustrates that so powerfully. So thank you. As we come to the end of the session, I'm going to circle back round to everyone and ask you each to share a key takeaway with participants watching from around the world who may themselves be exploring how to address economic abuse within their justice system or already doing so and are seeking to improve it. So can I come to you first, Cass, please?
Thanks, Nick. I just want to respond quickly to one point that Jenny made, if that's okay, and then
Absolutely.
I'll come back and answer your question. Jenny, thank you. That was so interesting. Really, really enjoyed what you said, and you've given me lots to think about. The one thing I wanted to come back on is one of the main points you made about the criminal courts and the family courts and the disconnect. And I guess what I wanted to emphasize was that for the story you told about the perpetrator who is now going back to the family courts and saying, oh, but I've been exonerated, I think it's really important to remember that criminal courts and family courts are set up to do fundamentally different things. And a not guilty verdict is not the same thing as exonerated. It really isn't. It just means that for whatever reason, and I know you know this, Jenny, I'm just making this clear for everybody watching, but that to me is that one of the biggest disconnects of all. And I see it a lot with rape trials. With my other hat on, I spend a lot of time thinking about domestic abuse, economic abuse, and how the rape picture feeds into that. And we often see victims in court end up with a not guilty verdict. And it can make victims feel incredibly disbelieved and disempowered. So I think when we talk about the differences between the family courts and the criminal courts, we've always got to be super clear on that, actually. And I would be really interested to make contact afterwards. I want to know what happened when that perpetrator went back to the family court. I have a horrible feeling it didn't go the way we wanted it to. Anyway, so just to circle back then and answer Nick's question about where we are and what the takeaway is. I think my biggest takeaway is a positive. I've been really struck listening to everybody today by how far we have come in really not very long. So December the 27th, 2015 is 10 years ago. It's been a decade. And in that time, building on Professor Evan Stark's work, Nick mentioned Professor Evan Stark earlier. He was the academic who reintroduced the understanding of coercive control that has driven all of this change. We really have seen changes around the world. When you think about how long these systems of justice have operated, in 10 years, actually a remarkable amount has been achieved. And Nick, you've done some really important and amazing work around the recognition of economic abuse, which I think we've all realised or emphasised today is so important because it is the structural underpinning that we are really only now peeling away the layers to look at and see and name it for what it is. And it's only really when we do look at it, see it, and name it for what it is that we can start to take steps to address it and dismantle it. So I think that's my sort of overwhelming takeaway. It's a positive one. And then I think in terms of maybe not quite so positive, it does also occur to me, listening to these amazing women from the different jurisdictions that we've looked at, that every jurisdiction brings its challenges and there is still so much work to be done. So we've heard from Jenny about the very real problems that are introduced by trying to navigate this space, this ridiculous yawning chasm between the criminal and the family courts, which makes no sense to the survivor at all. We've heard from Angela about how Australia possibly has still got some catching up to do, even though it's, making great progress. I don't have it in my heart to say anything negative about Scotland because they've been so progressive and are literally so far ahead with the Domestic Abuse Scotland Act. And I'm going to stop there. Thank you, Nick. Thanks for inviting me.
Thanks, Cass. You've got about a minute, and I recognise that we've not talked too much about post-separation abuse. So talking about the Serious Crime Act, I know you played a major role in an amendment to that via the Domestic Abuse Act of 2021. Do you think just in a minute you could just make quick reference to that and whether we've seen any impact?
Absolutely, Nick. And I should first of all say that was very much your campaign. So at this point in time, Nick was the Chief Executive Officer of Surviving Economic Abuse, which she set up. And I really just followed your lead and was privileged to help you out a bit with that campaign. So what Nicola and I realised was that the way that Section 76 had been framed meant that it excluded post-separation abuse, which was, again, went back to the fact that the government didn't really understand the behaviour it was criminalising at the time that it drafted the legislation. And it left us with this chasm because it meant that post-separation, which we all know is the most dangerous time for survivors, it's well recognised now in research and practice that separating from an abusive partner is where a victim is absolutely at her most vulnerable and most in need of support. It's often also the point where the economic abuse ratchets up. And it was exactly at that point that the criminal law protection was being withdrawn. So Nick ran an amazing campaign. I helped a bit, and we managed together to persuade some parliamentarians, members of the House of Lords, that this needed to change. Domestic Abuse Act 2021 brought in a provision specifying that the post-separation abuse should be included part and parcel. I should just say that Scotland, of course, never made that mistake. They are practically perfect, but they incorporated post-separation abuse within the Domestic Abuse Scotland Act. And a take-home for jurisdictions around the world: please don't use the end of a relationship as a legal marker. It's not helpful. It doesn't help survivors. In fact, it makes a vulnerable and precarious situation even worse.
Oh, an amazing message to end on, Cass. Thank you so much. I'm moving across again to Practically Perfect Scotland with Marsha. And the same question for you, Marsha. What would be your key takeaway that you'd like to share with participants who are thinking about how they might address economic abuse within their justice system or seek to improve it?
Yeah. First of all, Cassandra, you're making me sound like Mary Poppins, and that worries me. But
I was
just
thinking
to say,
about Mary Poppins as well. Practically perfect.
if only I had all of her magic. But anyway, I guess listening to everybody, Cassandra, great reminder. So our bill wasn't implemented until it started in 2019. Then COVID, of course, hit in 20. So the fact that we have a significant amount of change and a lot of improved success, and especially in the prosecution element, I suppose reminds me that we should look back once in a while as well as looking forward. I do think, as I always am, I'm always struck by the fact that really different legal systems, jurisdictions, cultural histories, and yet, because of patriarchy, women's lives are still being managed by the system and by perpetrators in almost identical ways, which I suppose leads me to my earlier comment, which is we have to use this gift of being able to draw a very visible line between the structures that oppress and constrain women and children, and their experiences and their struggles to be free from coercive control. And I think part of doing that is to look at a woman's whole life and that helps us move away from this incident focus, which has been in place for so long. An example for me is the mention of property settlements. If we're serious about helping women expand their space for action, I think the very first place we have to look is, how do we make them less poor, right? And economic abuse is one element, and a very big element of that. And if you think of it broadly, it extends into property settlements. It extends into one of the campaigns we're doing right now is shining a light on the debt collection practices of local authorities, which are horrific. And also, just this week in our housing bill, there was a mechanism for removing women's victims of domestic abuse, quote unquote, joint liability for debts under their joint tenancy. So, it filters through every part of women's lives and children's lives. And I think that the more we step back sometimes and we look at the whole life, the more tools we have for interrupting this toxic, dynamic in which the system and the perpetrator hold all the cards. So I just would say, I think, we're working really hard on council tax debt and a whole variety of what's the word? Levers for change that I think don't rely on the goodwill of financial institutions, which we need also, but which are the ones that are sort of putting the sticking plasters on when the system and the structure have already created the problems. So, and also the lack of access to legal services. Jenny, the stories you told are just such unfortunately common to us in Scotland also, and that's a really big issue for us. Is if women don't have good advice and good representation, they're never going to come out of this system on an equal foot with men. Okay, I'll stop.
Wonderful, thanks, Marcia. And yeah, back to the piece I think that's been consistent through all the answers is that real crucial importance about understanding coercive and controlling behaviour. Angela, circle back to you now, please. What would be your takeaway or thing that you would like people to be thinking about when they're looking to develop a justice response and/or seek to improve it?
Yeah, well, I suppose in Australia we really have learned from the UK. We've taken what's the legislation over there and are applying it. But legal nerds, the application of the law is drafted differently, and each state has drafted it differently. So there's going to be microcosms of practice that are taking place, and that we're going to have to sit back and wait and see how it unfolds and which is the best, perhaps, jurisdiction that hits the mark the best. I think that it probably is going to take a while for even a standalone coercive control matter. Like at the moment, I think that it will be coercive control connected in with physical, like the other sort of strangulation, rape and other offences. And so I think if it's going to take a while, perhaps for the standalone coercive control, I think it's going to take an even longer for there in a criminal matter to be kind of just economic abuse. But that doesn't mean you can't work towards that. But I think it is going to be a long period of time. I think that possibly that in Australia, the family law system is really where coercive control, it's going to be the main jurisdiction in which this is played out, because women in general don't want to go criminal. There's a percentage that do, but the majority don't. But perhaps they will be going through the family law processes. I think that I'd just like to also echo what Jenny said around the disconnect. I think there's a lot of work in Australia that has to be done between the criminal law and the family law system, and we've got extra layers of distance in the sense that the criminal law is a state-based law and the family law is a federal law, and there's a whole range of problems and issues around and disconnects that happen because of those reasons. But there's real issues with perpetrators playing off in those systems and seeking more time and using strategies to get one-upmanship, I suppose, in either jurisdiction, actually. So I'm not sure I answered your question. I'm probably doing a little bit of a wrap up of where Australia really has used that information from jurisdictions like yourselves, are starting to implement it, has gone ahead in the family law jurisdiction in a really positive way. And we've got to wait and see, I suppose. We're in the wait and see stage. But the positive thing about a lot of family lawyers also work in domestic violence protection orders, so getting protection orders for women, and you do start to wonder, as they become more across the issue of financial abuse, get more attuned to those issues, more comfortable in arguing them, will they start to argue those more in the protection order system as well, you know, around economic abuse and financial abuse? And it may be that there is a positive flow-on effect of this family law changes that happens into the protection order. Again, that's a wait and see. We just have to wait and see how this plays out. And there's only so much change a system can take. You know, you can't start to, unless there's, you know, real problems, you don't want to be starting to change laws. You've got to kind of wait for it to settle and see, because otherwise people start to go a bit mad with, you know, oh, here's another change. So yeah, but
that's been so helpful, Angela. And I think just, you know, I'm learning so much through this conversation. And, you know, another key takeaway, we do know that a lot of victim survivors won't have contact with the criminal justice system, but as you say, will absolutely be in that family justice space. So, you know, so important that we're aware of that and are able to, you know, support in the way that we need to. And as you say, then, you know, bring that into some of the other protections that exist through protection orders. So thank you. So to wrap up with Jenny now, same question to you, sort of key takeaway for those looking to introduce an understanding of economic abuse into their justice system, or those who are seeking to improve how they're doing that already.
Great. Well, I'm going to be greedy and go for more than one takeaway because it's been really interesting. But can I start by reassuring Cassandra that the family courts didn't actually entertain this in this particular case? However, my concern that case illustrates quite starkly, because that poor woman had to go through 12 days of the entire process, re-traumatizing twice, and also, of course, the results so clearly emboldened the perpetrator, who will, of course, never be out of her life because they share a child, emboldened him to believe. So it's about the optics as much as anything else, whilst fully appreciating, of course, the process is there for a different reason. And what often happens is it's before you even get there. So somebody will be forced to report, to Angela's point. They may choose a family jurisdiction because they may not actually want a criminal prosecution of the father of their children. So they may choose to seek to protect themselves and their children through the family system, but then be told that if they want legal aid, they're going to have to report this to the police, because it might be that bail conditions could protect them similarly and save the public purse. So they report, nothing then happens, potentially an arrest, possibly, but often not a charge or an insufficient charge because of an insufficient recognition of what's actually happened. And that, of course, emboldens the perpetrator. But of course, it makes the survivor feel, well, nobody believed me. They didn't charge him. Nobody even arrested him. And as a consequence, whilst I've been told by my lawyer that I should be raising this in the family proceedings because I and my children are at risk, I'm not going to be believed. And so there's that, the optics of the interrelation between whether we're taking this seriously or not is critical for the survivor journey. And you place that against the backdrop of a non-trauma-informed court space anyway. It's a really hard thing to go through. And then you layer on top of that the fact that our system is geared towards incidents, and it's very hard to imagine that you're going to be believed as you try to achieve best evidence within that context about a journey of control. But one of my takeaways is redoubling my efforts to see how far back we can go with this reimagining of a system which allows that process of coercive and controlling behaviour, including, of course, economic abuse, to be exposed evidentially and to make sure that it actually counts within the civil process, which is where I practice. And that includes, and I think the one takeaway and the really important piece of work that Cassandra raised is this post-separation abuse. The one thing I'd add to that is to make sure if anybody's devising a system, make sure that that includes actually using the court process itself to abuse. That is often used as part of the abuse mechanism. Making perpetual applications to court is a form of abuse, and that's often a practice form, particularly in circumstances where perpetrators are litigants in person and they just repeat the bending of the court rules, and the repeat applications are abusive in themselves. So that's one to watch. The other thing I would say, a key takeaway, everybody has relied on some data to back up what they've been arguing, and we are very data poor in terms of what we've got, not least because we don't have much transparency in the family justice system in the UK. Data is key. It's key to the power to prove what's actually happening, and in fact even to prove prevalence, because we still have a measure which doesn't take into account coercive and controlling behaviour and economic abuse properly, and therefore underplays both the prevalence of domestic abuse but also its very gendered nature. So I think anybody starting needs to be revisiting the data so that the actual issue creeps up the political agenda, because the one thing we can all be sure of is that we're underestimating the level and scale of the problem. So I'd say data is my big takeaway, and carrying on focusing on how we can capture better and more accurate data around the problem. And then with that, breeding a better understanding. And I'm really heartened to hear Angela's stories about some of the really good training that's taking place. And I believe that training needs to be not just about the decision makers, not just about the judiciary and the people who are in those positions of power, but also the general public, so that we just become a less tolerant society, and we're recognising the hidden abuse, even if it's in the private and not so much in the public sphere. So I think it's about us as a society teaching our children a zero tolerance and understanding these economic abuse at that very fundamental level, because I still have people coming to me and I'm the one to break the news, and that shouldn't be the case. I'm the one saying, no, £5 a week, that's not okay. Accounting for having to buy tampons, that's not okay. Not being allowed to go to college, that's not okay. But that is economic abuse, and you can see people saying, oh, well, I can see that now. And that I shouldn't be the educator for that. So those are my main takeaway is redouble my efforts.
I think we're all going to be doing that after this conversation. And what an important point to end on, Jenny. And the aim really of this summit overall is to raise awareness of economic abuse, so you're not having to be the educator, and that hopefully we start to be in a position where people are recognising and challenging, most importantly, the behaviour of those perpetrators. So such rich learning, and I'm sure following on this panel, members are going to be continuing their conversations. I know you're going to be circling around and asking each other various questions. It really demonstrates to me the importance of this international space and us learning from each other so that we can really accelerate our efforts moving forward. You know, we all have limited time, we have limited resource, but coming together we can make a huge difference. So I want to thank all of our panelists once more, you know, for being in this space, enabling us to do that. As I say, I've taken so much away. I'm sure everyone else who's been watching this session will have done the same. Thanks so much to everybody who has asked us questions. We will be responding to those online. And yeah, thank you very much indeed for everyone who's watched and attended this session today. We'll see you in the next one, so don't go away.